this.
I let the younger guys wear the ties too.
Yeah, I'll just do a quick handout so in our office, the planning process that we do with clients is, the planning process that we do through a couple different software programs that we use, we always incorporate plan giving into our conversation. So we always try to help educate people as far as our clients is concerned to let them know the different types and different ways that you can do giving, not only currently today, but for like legacy planning as well. And the handout that I just handed you is kind of giving you some considerations of some techniques, some giving techniques, as well as some considerations of why you give. Everybody knows why we give, and then there's the last page is about how to use life insurance as a giving, which is more of a legacy type situation. So and normally what we use is during a person's the age of 65 or 70 years of age, typically we'll see people will give an appreciated asset, and that's very easy to do, whether it's a stock or a mutual fund, or it can be real estate. It can be really any appreciative stock or an asset. And the foundation uses a form that we use that is pretty simple to do, and the gifting goes through. There's certain parameters that we need as far as information, but then we use that to help clients give to the different organizations that are organized by the Greater Township Community Foundation. So, once you reach that age 70 and a half, a lot of people forget that they can use their required minimum distributions. It's another handout, a full handout if someone wants to get these out. And now this is just the IRS tax table that they use to calculate what your RMD is. And an RMD for somebody that turns 70 and a half is that from qualified plans, whether it's an IRA account or 401k or any of those types of assets, they have to do what they call a required minimum distribution. And based upon your age, there's a factor that the IRS table uses, and that's what your hand seeing at there is, and that's a uniform table. So that's for like typically a husband and wife, to where the spouses are less than 10 years apart in age. There's a different table if they are farther apart than 10 years. And then there's a table for single spouse. So this is the uniform table. I didn't want to print all three tables, but you'll get the idea that there's how the calculation is made. And that's as simple as you can give either part of it or all of your required minimum distribution to charity. And we're finding a lot more of that happening in our world, as far as clients saying, well, I've accumulated these assets, but I really don't need them. So how can I get rid of this asset or gift it without paying any taxes? So it's a great way for them to pass the asset on to a charity and not have to pay any income taxes. So we use this a lot with our clients that are age 70 and above. So, any kind of questions or concerns that why we're doing that or how it's done? Calculation is pretty simple. And so is the form filling it out. So it's getting the client to say, yes, I would like to do this. That's the challenge.
So for those of us who represent nonprofit organizations, it would probably be a good idea to remind donors somehow through a marketing piece maybe about a required minimum distribution and how it can, be used.
We're sending out to clients that coming up here in the next month or so, we'll send out reminders about their RMD if they haven't already done it this year. We'll send out reminders to our existing clients, reminding them of their options to choose from.
Okay.
So, yeah, I think it's a great piece to send out to the non-profits to remind them that their donors have the ability to do that and reach out to their donors and say, one of the ways you can do that is through your required minimum distributions.
Thanks.
A lot of times people will use their cash that they might have, but then they've already paid tax numbers. So this is just another alternative, basically, to that, to give them. But there's a lot of neat techniques. You'll see with that first handout, you'll see some different techniques that are used. If anybody wants to discuss how those work, I can certainly do that. But I would say the most common that we see are typically just appreciated assets, whether that's an individual stock or a mutual fund or something like that. That's normally what we see. Occasionally, we'll see a charitable remainder trust or charity annuity trust or something like that, or use life insurance. I've sat on foundation boards. This goes back a few years ago when I was on in Des Moines. I had an office in Des Moines, and I was on the Des Moines General, if you remember that hospital that used to be there. I was on their foundation, and one of the pushes that we had was legacy planning for that foundation. And we all bought life insurance policies. Well, the foundation owned them, okay? They were the beneficiary of the policy, but we paid the premiums. The individual paid the premiums. And that was our gift, basically, was paying the premiums. Unfortunately, when Des Moines General pulled it down, they surrendered the policies and took the cash, and whatever they did with that foundation just basically went away. So, but that's a great tool. So.
Can I ask you another question?
Yeah.
Sorry, I'm going to keep. Can you talk a little bit about charitable remainder, annuity trust and remainder trust? I know they're complicated, and maybe that's something more for the attorneys.
Well, but go ahead.
You guys probably have more information on those
Okay.
than I do. Really what it is that depending upon how it's structured, how it's set up is you can either make a gift of the asset to the charity and the organization, the not-for-profit can pay you an income back, or that is paid to the beneficiaries, and then the remainder of assets that are left upon the deceased goes to the non-for-profit. So it depends on how, there's all kinds of different ways to set them up. Some are charitable leave trust, remainder trust. So kind of can get a little bit more in tune with what the client is actually wanting to accomplish and need. But yeah, we've used them a couple of times. Doesn't happen as often, but it does.
I actually have a question back on the IRA minimum distribution.
Yes.
Can you speak to, I know talking to donors who may have their own IRA checkbook, and when the timing of when they're making that donation to make sure that they're, rather than having their administrator send the charity the donation, they're writing a check.
Yep.
And isn't there kind of a lag time as far as if they don't get that in before the end of the year, it's not counted?
Yeah, we always tell our clients basically to try to do it before December 15th. Just to make sure that the check is received and deposited, that kind of thing, just to make sure that it goes through the system. You don't want to write the check on December 31st, even though it's probably still legal. We like to make sure that it's gone through the system and make sure it's cleared and that kind of thing. So we always try to, we don't want to have people walking in the door or calling us and saying, hey, I want to make my charitable donation and make my RMD on December 31st. Our process takes a little longer than just that time frame, so we always try to encourage our clients to get that done before December 15th. So. But good point, because some of them do have checkbooks that can just write checks from. But make sure they're writing the check for the RMD or a portion of it or whatever. So, yep. You guys want to?
Let me follow up a little bit on what Tom had to say about the R&D, or what you also would call it, qualified charitable deduction. My wife and I both turned 70 and a half this year. So we have used QCD or the RMD, it's interchangeable, for purposes of giving charitable contributions. And one of the reasons that is makes more sense than I think it ever did was because of the Tax Act of 2017 that raised the standard deductions. There aren't that many people that are probably going to use the itemized deductions anymore. Would you agree, Tom?
I would be absolutely.
Yeah. And with that being the case, and I know there was some concerns at the time with nonprofits about how this was going to impact how people gave money to charities, because part of the reason we give money to charities is obviously for altruistic purposes. There's another aspect to it, which is tax reasons. So you've got to take a certain amount out when you turn 70 and a half. I think, correct me if I'm wrong, Tom, the first year you don't necessarily have to take it out, but if you don't take it out the first year, you're going to have to take out double the second year. Correct. And if you're still working like I am, you still want to look at the tax aspects of that. So it makes sense to do that in the first year. So Patty and I did is we sat down, we looked at the charities that we'd like to give money to. And then we talked with our financial advisor, and they were very helpful in assisting us in that regard. And we have given most of what we have to take out for qualified for distributions this year. We've used the QCD or the RMD. We're going to use some more later this year. And the significance of that is, number one, you don't get a tax deduction, but you don't get taxed on that. And that is money that you put into these accounts for purposes when you were younger, for purposes of saving some taxes at that time. So if you use that for purposes of making your charitable contributions, something that you would have been taxed on otherwise, you don't have to be taxed on. So I think it really, it is a good thing to use under those circumstances. For those, and there's quite a few in here that haven't turned 7 and a half, I can tell. But it's something to keep in mind, okay? To follow up with what Tom said about charitable trust or charitable remainder trust, and I agree with what you said. You know, a lead trust is one where the charity gets the money, the income, if you will, and then it goes to somebody else in the family, and then the remainder trust is just the opposite. Part of the reason I don't think those get used as much as they used to is because at the present time, in terms of death taxes, over 99% of us, or right at 99%, are not going to have to worry about death taxes. Remember the old saying, Ben Franklin said that there are two things certain in life, death and taxes. Well, it used to be that it was not only you got taxed before you died, but many times you got taxed after you died. At the present time, a couple can basically have assets of $22 million and not have to worry about even filing a federal estate tax return. And here's what I mean by that. Every American citizen has an $11 million exemption from estate tax. If they are married, and if certain of your assets go to your spouse, you can use what's called portability. It's a relatively new concept. If you don't have to use your $11 million or most of it, that gets transferred to the surviving spouse at the time of his or her death. And so you're talking about basically $22 million. And sometimes this year, for a couple that were below the 11 million, but we went ahead and did an informational federal estate tax return because death taxes are somewhat of a political football. Several years ago, the deduction was 3.5 million. And then it went to 5.5 million, indexed for inflation, and now it's at 11 million. It may go back some, you never know about those things. It's kind of like capital gains, that's a political football too. But at the present time, almost all of us don't have to worry about death taxes. There may be some income tax things that you have to worry about, but death taxes not so much. And because of that, some of the ways that you could try to save money that were used maybe 5 or 10 years ago, Tom, you just don't have to really do now.
Right.
So what are the other things? If taxes aren't a concern, what are the other things that we should be concerned about when we think about things? Well, one of the things that your CPAs and lawyers and financial advisors are concerned about, and I know you're concerned about too, is succession planning. If you have a business, if you have some farms, and some of you are farmers, so your business is farming. But if you have some things like that, how do you decide what you're going to do in terms of the business? In our circumstance, we have 3 children. One of them is practicing law with me. And if as that's the case, and as long as he stays doing that, he's got a stone in the building that says Patrick Mahaffey Lawyer, so as his mother said, you can't leave now. You're in stone, all right? should I take into consideration the fact that he's with me when I consider succession planning? The answer is absolutely yes. So those are some of the things that your financial advisors and lawyers and CPAs can talk to you about too. The interesting thing about our assets and how they should be divided is that almost all of us want to try to be fair. And the question becomes, what is fair? And fairness isn't always equal. Well, sometimes it is, but sometimes it's not. If you have a son or a daughter that has been involved in a business with you for many years and has helped you continue that business and grow that business, do you need to take that into consideration when it comes to how you're going to divide your assets on your passing? I would say you should. Because, again, I think that's something that is fair to think about. So those are some of the kinds of things that we talk about. Taxes, again, not being quite as important now, but there are other aspects in terms of your assets that still need to be addressed. Tom mentioned a word that I think is an important word, and that's legacy. As we get into our later years, and my best friend in high school and I were talking recently, because we both turned 71 this year, and using a sports metaphor, I said, well, we're in the second half, and he said, Mike, we're in the fourth quarter. and he's right, okay? He is right. And I hope I live as long and as healthy as my friend Phil Palmer here. But if I do, that's another 20 years. So what is the legacy? What is it that we want to try to accomplish, not only with our money, but as we show our children, nieces, nephews, whatever, how it is that we have used our money, and how it is that what we want to impart to them in terms of money. And you know, I've been practicing law for over 40 years, and money is good for what it can do for us. It's not good sometimes for what it does to us. It's just not. And so the question is, who's going to control that? Is money going to control us, or are we going to control our money? So those are important things. And when I talk to clients in the privacy of my office, those are some of the concerns they have. How are things? How do we impart to our children, our nieces, our nephews, whomever, grandchildren, what it is that we have and how we would like to see it be used. And so those are, I think, are important things. And then lastly, for this purpose, and I'll try to answer any questions you might have, you always take into consideration family considerations. Every family is different, okay? And the children within the family are different. You know, I have clients, and it's not that they don't love their children the same. I had one in a couple of years ago, and he has 3 children. 2 of them are very fiscally responsible, and 1 not so much. And he was burdened by that to some extent. And we were talking about different things you could do in that regard. And finally, we reached the conclusion together that you can only control so much during your life, and you really don't want to try to control from the grave. Sometimes people want to control things during their life, and then they want to control it for the generations to come. And it's good to have a guidepost, and it's good to say this is what we want to do. This is what wills and trusts are for. But if you try to do too much in that regard, it sometimes just doesn't work out too well, and it causes problems for generations to come. So that's one of the things that I think everybody has to look at too. And then 2 other final thoughts. Number 1, communication. Your financial advisors, your CPAs, your lawyers cannot talk to other people in your family without your permission. They simply cannot do that. It's almost like the confessional. I mean, sacrosanct thing to that, and you have to be very careful about that. So if we get a call in our office saying, I'd like to talk about my mother's will, I always have to say, I have to have your mother's authorization to do that. If she comes in with you or she calls me and says that's all right, that's fine. But I cannot do that unless they give me, she gives me permission to do so. And honestly, it's best for people to hear what it is that you want to do from you than from a financial advisor or a lawyer or a CPA or somebody else. Because there may be some things that are going to be a little different, maybe things that need to be explained. And sometimes you can't do that. Sometimes there are things that they just want to leave with us and we say, fine, I understand that. But my experience is that if you don't do that, there can be hard feelings later on. And one of the things you don't want to have happen, it doesn't happen very often, but it does happen sometimes. You don't want a family to be split because of those things. I always say to my clients, when we're done, I want you to still be able to have Thanksgiving dinner together. Now, sometimes I can tell that they aren't having Thanksgiving dinner together the first time I meet them. So then I don't have to worry about that so much, okay? But I think that is, I think that's important. And then the last thing about charities is this. Those charities that we give money to, whether it be GPCF or the Salvation Army or our church or whatever organizations, when we're gone, they are still going to be doing the same things that they did when we were alive. Hopefully doing it the best of their ability and using money carefully. So it's not only important in terms of what we do with our money when we're alive, but it's also important as to what we do when we're gone. That's it for me.
Yeah, I gotta reiterate something. Mike said something about that you literally cannot speak to children or other children. You can't even literally speak to a spouse if we're in regards to a spouse's account. I have to have authorization from the other spouse to release information to that spouse.
Yeah, that's
So
true.
it's a very, very fine line that we have to follow, and very heavily regulated. So always good to have those. We're actually starting to put even trusted contacts onto our clients' files. And a trusted contact is, it's not somebody that has access to their accounts, but if we can't get a hold of somebody, we have to have somebody who we can contact and says, okay, this is a trusted contact that you can call in order to find out where I'm at and how to get a hold of me. So we're starting to add those onto clients' files as well too.
So PJ is going to mention a few things about things that happen during our lives, and there's a big change that is coming in terms of the guardianship and conservatorship law in the state of Iowa. Go ahead, son.
All right. I'm Patrick Mahaffey. I'm Mike and Patty's second favorite child. If you've known my sister, which a lot of you probably do, you understand why I'm the second favorite child. I practice law with my father in Montezuma. I live here in Grinnell. And I'm going to talk a little bit about guardianship and conservatorship. I know today's topic is a lot of fun, taxes, death, and now I'm going to talk to you a little bit about end-of-life planning. But they're very important things to discuss, and I'll touch on at the end a little bit how they connect with giving, particularly with the new law coming. So first, I always go into something with the idea that even if I think I know a lot about it, I presume I don't know much, so I'm just going to give you what the code says a guardianship is and a conservatorship is. For financial purposes, conservatorship is what would be your primary focus here. So guardianship is a person under Iowa Code section whose decision-making capacity is so impaired that the person is unable to care for the person's personal safety or to attend or provide the necessities for the person, such as food, shelter, clothing, medical care. So when you think of a guardian, you might think of maybe a parent's passed and a minor needs a guardian. You have to establish a legal guardian for them. They would be taking care of their personal needs. Maybe end of life, or we have a loved one who gets dementia, can't take care of themselves, those type of things. The guardianship is often appropriate in those type of circumstances. The guardian part of it is just the physical care part of it, the health care, the medical decision The second part is a conservatorship, and that is, under the Iowa Code section, a person whose decision-making capacity is so impaired that the person is unable to make, communicate, or carry out important decisions concerning the person's financial affairs. So that now we're talking paying bills, managing a bank account, those type of things. So they divide those two up because sometimes you only need one as opposed to the other, right? Often with a minor child, you may not need a conservatorship if you're not managing anything for them. By the time they get 18, they can make those under the law decisions themselves. How this relates to estate planning and end-of-life care is, I don't know how many donors for this foundation you've come across with this kind of concern, or someone who you're dealing with a conservator or a guardian on behalf of someone. But the giving part of it and the planning part of it is important because in order to establish a guardianship conservatorship, you have to file with the court and you have to establish under the law, it says here that person meets that criteria. And then the guardian and conservator, or again, guardian or conservator, has to file an initial report and then annual reports as it pertains to assets, management of those assets. So in some cases it might be a family member who's managing that. In some cases it might be a financial advisor, a third party, and the purpose of having that added in there is that there is record when you start. All right, here's a list of the assets, the inventory, accounts, all of those things, and here's our initial report every year showing that this is being managed appropriately and everyone is acting in good faith. So it's important in maintaining that clarity. The law is changing, has changed, will be in effect as of January 1st of 2020. I won't get into all of the changes of that because in part I'm going to a continuing legal education workshop on this, so I'm still learning the new law, but I won't go into all the details of how it requires background checks and kind of the added things it requires for a guardian and a conservator. I'll more touch on how it affects giving and planning. So the two things you want to look at for a conservatorship, if a conservatorship is involved with someone who is giving at the end of life or charitable giving, you need to provide, well, first of all, if anyone is running an organization and they do have someone who the conservator has been managing and donating money, have them do that again by the end of the year, because when the new law changes, one of the big things is you're going to have court authorization for any type of giving on anything. So you're going to have to get a court order on those different things. It's going to be so that courts don't move quickly. It's one of the main frustrations that most people have with the court system. And so once January 1st comes, that conservator is going to have their attorney get a court order saying that they can give X amount of money to X amount of organizations. Right now, as the law stands through the end of the year, they have that authority is granted to them in the initial conservatorship. So you don't have to then go to the court every time you want to give something. You're given that unless for some reason that is objected to or the powers are limited by the court to do that. The reason that's important is the time-wise, but also the court now is going to look at, in terms of charitable giving, the conservator has to show that on behalf of the ward, the person who would be in the conservatorship or that they're acting on behalf of, that there is an established pattern of giving to this organization. So if you have someone, and this might be a good thing, if you work for an organization that takes charitable contributions, to talk to people about, which is that, even if you don't feel you can give, the maximum amount as it goes to, as a younger person, I want to do my duty to society and give, but I've got student loans piling up around me, and so I can't give as much as I hope to give at the end of my life or years after working. And so what you can establish, though, before a conservatorship has begun is a pattern of giving. And so if you have someone who's giving monthly gifts to your organization or giving annual gifts, obviously I know you keep records of that, but it would be important in the light of a conservatorship or a potential diagnosis of dementia or something along those lines, have a conversation with those donors about, making sure they have record or providing them record of their donations, so that in the event that's ever contested in a guardianship or conservatorship, you have that record to show the court, this is something this person did throughout their lives. Clearly this foundation, this organization was important to them, and so the conservator would be able to point to that and say, I'm going along with what my father or mother wanted, or what third party, my client wanted, because they told me this and they established this pattern prior to the conservatorship being established. The second part is, Dave kind of already touched on, which is you prove that the gift is beneficial with purposes of the protected person and the ward's taxes. That comes into play, particularly 70 and a half, or you have larger assets that are being managed by a conservator. But one way to maybe expedite that process on the organization's end is, you don't have to be tax experts, but to encourage whoever would be the conservator, or whoever is the donor prior to any type of conservator in place, to establish with their CPA, or maybe just share with whoever may be a caretaker at the end of their lives, how this benefits in terms of financial taxes, right? This giving does this for purposes of lowering taxes, or this giving for purposes of lowering assets towards the end of life, right? To avoid estate tax maybe, or something like that, you give for a period of years prior to end of life. So those conversations, while not fun ones, and we all live and presume, want to be optimistic in that, we're all going to pass in our sleep and not have to deal with some of those things, but that's not the reality of life, unfortunately. And it's important that, what I always tell clients is that this is an enjoyable conversation, but having this conversation should provide some peace of mind when you have that decision, right? It's because the clearer and more articulate you are about what your goals are, what your passions are, what your desires are, whether it be physical or financial, with your children or whomever, your financial advisor, your lawyers, the more likely it is that everyone understands, is on the same page in the event that tomorrow you got a car accident and you weren't able to make those decisions on behalf of yourself, right? So those plans really are how conservatorships affect that, and the new law just provides layers and layers of more protection and more requirement with the court to do that. It's going to be a lot less for organizations, conversation with the conservator, them signing off, right, using their given authority to give a donation to an organization, and more, all right, we got to fill this out, and we might have to attach previous year's giving of that person, or something from the CPA, or a lawyer basically establishing with the court the reasons that we're doing this for tax benefits. The new law, guardianship in terms of planning, like I said, I'm not going to get into the weeds of the new law, but essentially what everyone should be prepared for is it's going to be a lot more, it's going to be a more involved and costly process to establish a guardianship and conservatorship. There are pros and cons to that. The pro I kind of already stated, which is that there are going to be more levels of protection to avoid people being manipulated. The con of that is nothing is going, if something happens to someone, you need something quickly, you're not going to be able to do it. It's going to be kind of a longer process in getting that set up. You're going to have, like I said, criminal background checks. You're going to have different people appointed to represent different interests of the persons, and that part of it, affects a vast majority of the situations that people get into guardianships and conservatorships, which is, none of us want to enter into that, right? And so most of the time, families put that off as long as possible, often too late. We're already beyond the point where mom or dad is not able to make decisions, or forgetting to write these checks or whatever it is. And so it's going to be So the main part there, like I said, touches on the giving is you need to establish a pattern of giving prior to involvement of a conservator or guardian in the court, and provide a kind of detailed, not too detailed, but because most judges, most lawyers understand the benefits of giving as it relates to taxes, but particularly giving to a specific organization, how that would benefit that person on behalf of the guardian, conservator on behalf of that person, how that would benefit their taxes financially.
Thank you, Seth. Let me just add one thing to that, which we call him PJ, he goes by PJ or Patrick. That is very important, which is this. If you've established a pattern of giving, you want to make sure that whomever becomes your conservator knows that you have done that and that you want that to continue. Because sometimes what happens, and this is just human nature, but sometimes what happens is when somebody else is dealing with your money, and they may very well be people that are going to inherit your money, and I don't mean this in a bad sense at all, but you think, well, boy, mom and dad, they like to give money. And you have to be careful about that, because sometimes I've had clients say, look, I don't mind mom giving money, but every time she sees some TV evangelist, she's starting to just give money to whomever that is. And I had one of them in, he said, have you seen the house this guy has, or something. So you gotta be careful about that. You don't want, if there's a pattern of giving that is out of whack, if you will, or out of kilter because of what's happening to somebody, that's one thing. But you wanna make sure that the person who is going to take over those responsibilities for you understand we would like you to continue to do that. So.
One thing, I don't think I'm oversharing, one thing that my parents have in place is they have just an Excel, at the office, an Excel sheet of who it is that they give to, which they don't give to me or share to me, but I know to be there, so then the event that passes on, I know what they're, and I, being a parent, or being their child, know some of their interests, but, my other siblings might not know that having me not been in the office, and so, keeping that record is important too, again, with the family dynamics, is because then, I could go to, just to use my family example, this wouldn't happen because we all get along, but, and say, hey, I know they give to X, Y, and Z, right? Well, that doesn't, they might, well, what do you mean, but if they have it written down, right, and then it's not me telling them, it's not me potentially misleading, which you can get often, particularly when we're talking bigger families, talking farm families, right? Favors being used for people who worked on the farm and didn't work on the farm, whatever it is, right? Just normal family dynamics. So having a record, what a surprise the lawyer's telling you to have a record, is important because it also makes the people who are going to care for you or take care of things after you're gone, their lives a lot easier in the event the family is not agreed on things.
I have a question.
Yeah.
On the conservator thing, as far as the court order, is that for every charity, or just once a year saying, here's a list of the charities that they gave to, and we're giving that? And
Right,
that's just
yeah.
the court order? And that's
So
an annual thing that you gotta go get the court order, or is it standing instructions? Or?
it will be, my understanding of the new law will be that you have to get court authority to do that. Around here, I would think most judges will give that to them upon one filing of essentially a separate filing. It used to be that when you file, you'd be given those authorities when you're granted the conservatorship. Now, essentially, they're saying, if you want to do something outside of like the basic, just paying for things, taking care of things, then we want to make sure we have the extra authority to do that. Most judges here, but I haven't talked to them, but having worked with them, will probably just make sure that there's one filing on record stating and providing an attachment of those that they give, that the ward gives to regularly, and just do it once, and then if they want to add something to that, they have to do separate.
I think that's a good point. But you establish the pattern of giving, and then you can show the judge
Yes.
what that is.
That's right.
The Iowa State Bar Association has already expressed some concerns about this new law. Not that we don't want to, we understand that people need to be accountable for what they do. But what happened is, because of a few very egregious situations, and those happen unfortunately, so there was a committee that got together and put this new law together, and it included some law school professors, and God bless law school professors, okay? But they live in a different world, and they're thinking about every kind of contingency you might have and how we can address that. So I've got a friend that's a lawyer in Iowa City, and he stopped on the way back from a bar meeting. He's a former president of the bar, and he said, I expressed some of my concerns. So the Iowa State Bar Association is going to go to the legislature in January, and see if they can maybe change some aspects of this. Because the other thing is this, and don't get me wrong, Tom, PJ, and I, we like to make money, okay? We do, we all like to make money. But part of what's going to happen here is that it's going to cost a lot more money to have to establish these things than it did before, because of these new rules and regulations. And some of them, I think, are fine, but I think some of them are maybe overkill, so.
It'll cost more to maintain them too.
Yeah, it'll just cost more to
Regular
maintain.
filing,
Exactly. So,
What's the
No, go ahead.
I mean, the liability to the nonprofits, if we get a check, the Grand Park Sheet gets a check for $1,000 from a charity or a conservatorship, do we not accept that check until we get a court order from approving that? Do they have to provide that with the check if
you
we
know,
take it? What's the
yeah.
liability?
Austin, that's a good question. This year, previous years, I would tell them, Chloe, you don't have to worry about that, okay? Next year, that is a good question, and I'm thinking about that as we talk. I still think that I still think the nonprofits would be okay because you haven't done anything. Yeah, exactly, I don't think it can make you liable.
It's not, yeah.
But could they come back and say, the court's
The
not
conservator
approved, they
could
come back and say,
But-
give us the money?
Well, the conservator could be held liable, I think you're right, Tom. And in that respect, I don't know whether somebody would try to come back, they probably would come back on the conservator, because I don't think the nonprofit, the nonprofit has clean hands. There's what's called the clean hands doctrine. And I think the conservator, under those circumstances, say, well, you took money and gave it to GPCF. Well, that's what mom or dad wanted done. So I still think that nonprofits would be all right. Having said that, it may not hurt, I don't think it would hurt to ask for a copy of the court order saying,
And how
we've
would we
agreed,
know- How would we know, like, that it's coming from a conservator? Is there, like, special checks that?
Yeah, so they would be signing
They would have a
these
separate
checks
account,
on
that's
behalf of, and they would put essentially, so if you have John Smith giving you something, but they are in a conservatorship, and Jeff Smith is the conservator, they would sign, and then underneath it would be basically on behalf of, so someone would be signing for them, and if you receive something like that, I guess, then I would follow up, just to, if that's the first time you're coming across it, if they haven't made any conversation with you, just to say, are you signing this on behalf of him as an agent, as a conservator, and if so, would you be willing to just provide us that documentation for our record? Just, I mean, I don't think it's, in terms of liability, I don't think it's necessary, just
The
because.
biggest risk is basically we have to look at who the conservator is. If
Yeah,
it's-
that's right.
If it's
Yeah,
Mike
that's right.
Mahaffey is the conservator, we're willing to take the check, because if it doesn't do
Thank
it,
you,
we're just gonna bill him. But if
Exactly
it's
right.
Jane Doe who has a negative net worth, we
Yeah.
might be taking risks.
no, yeah, that's a good point.
Yep.
You know, the other thing, I see Jessica, the other thing though I would mention is that with the power of attorneys that you do have now, you can have the option of powers of attorney of saying who you want to serve as guardian and conservator if that happens. And that helps save some time in terms of later on, but I was just thinking, well, whether that would help in terms of the new law, but I think it just helps in terms of setting up the guardianship and conservatorship. You're still gonna have to go through all the rigmarole, if you will. But you can, in the power of attorney form now, and I always say, you don't have to do this, but you can optionally, you can say, if it comes to this, and I need a guardian, here's who I want for that guardian, here's who I want to be the conservator. And that can save some time and money later on.
That's exactly what my question, power of attorney for financial matters, if a donor has a POA, does this apply?
Is it court, these are just court?
This is just court, yes.
let's talk a little bit about powers of attorney. Because this can be an effective way at a really minimal cost of doing some of the things that a guardianship and a conservatorship can do, okay? Sometimes what happens if somebody doesn't have a power of attorney and they have, they've lost mental capacity, physical capacity, whatever, then you have to set up a guardianship and conservatorship. And it costs a lot more money to do that because you've got to have somebody represent the person, the legal, to make sure somebody's not railroading something. So powers of attorney, general powers of attorney for business decisions are a very effective tool. And to go to your question, if you have a power of attorney that gives certain things, and on the power of attorney form, there's a list of things that you can give to your power of attorney. And then at the bottom, it says all preceding subjects or something like that. Most of the time people say, and I'll say if that's what you want, you just initial that, which means they can do all of these things. And if you do that, if you have that power of attorney, the power of attorney doesn't have to deal with some of these things that a guardian conservator would. Now, power of attorney still has a fiduciary responsibility. And under Iowa law, a power of attorney can be reimbursed for expenses, but cannot get paid to be a power of attorney unless the power of attorney itself says, I want this person to be, I want him to get paid some for being my power of attorney. So you got to be careful about that too.
So does this also, excuse me, does this also apply if a parent and a child is listed on the check, and because their both names are on the check and either one signed, or do you still have to go through all this?
No, that's a good question. I don't believe under the new law you have to, because that's a different situation. Mother has put her son on the checking account and saying, I have authorized my son, and you have to sign something to do that, Austin.
It's a joint account.
Yeah, it's a joint account, I've authorized my son to do that. Now, here's something you have to be careful about there. And the bank doesn't know this unless you say it. If you say, okay, I'm gonna set up this account, and it's gonna be a joint account, there's language that usually says, now this is a joint account, and if something happens to one of the people on the joint account, the other person gets the money that's in that account. Every once in a while, we have a circumstance where somebody's got a lot of money in the account, and somebody's on that account, and there are other members of the family, and most of the time this isn't the case, but other members of the family that say, well, should we be entitled to that? And from a legal standpoint, we say, well, the person that's the surviving joint tenant of that account legally is the one that gets that money. Many times they say, oh, no, I was only on there for purposes of signing checks for mom or dad. But you want to make clear too that is a situation that is understood, because every once in a while you'll have something where somebody will say, well, that's my money because I was on the joint account. And we were involved in a case several years ago where we were trying to trace back where that account came from and why it was done that way. And there was because of a change in banks, some banks change their names every 15 minutes. We had some problems with trying to trace that back. So.
Okay, when you say make clear, do you mean at the bank they
Well,
have a list?
well, yeah, I mean, if you want, and Austin, help me here if I misspeak. You can have a joint account, but the joint account, right on it will say, if one of you dies, the other one gets this joint account. If you just want them to be able to write checks on that account,
That's power of attorney.
That's
just
right.
an account on the
That's
account
different.
level.
Sign on.
But sometimes people don't realize that difference, if you will, and it's important.
Or
to
it's
do that.
easier to just go into your bank and add someone on the name as opposed to going to a lawyer and doing a power of attorney. Because even though power of attorney actually is a pretty simple process,
Right.
it seems more involved than maybe just going to the bank and adding.
Tenants and commoners, joint tenants, and full rights and survivorship,
Right.
same thing on all accounts.
That's right, yes.
So by having a copy of the power of attorney at the bank, that takes care of the situation.
I think it should, and again, it points out that the purpose of the power of attorney is for you to write checks. Not that you necessarily are gonna be the one that gets that account when mom or dad dies.
Power of attorney ends at death.
That's right,
Power of attorney.
it does.
Yes. The other thing that the power of attorney does, which is what it for establishing now, since it's gonna be a higher burden to establish a guardianship conservatorship, it lays the foundation for that, right? Which is that I filled this out when I was of right sound body and mind, and on there I optioned that this is the person I want to be my power of attorney. If they couldn't serve, I wanted this person to be. And I also checked that if I need a guardianship conservatorship, this is who I want it to be. And so it's like establishing a will for what your plan is in the event that you needed something like that. And then that can be pointed to and shown to a court, to a judge in the event that someone's contesting whether or not you or someone else should be the guardianship or conservatorship.
PJ, is there any change to how they determine diminished capacity where a conservator takes over?
My understanding, and again, I've read through it, have not had someone smarter than me explain it in full detail how it affects the practical elements. But my understanding is that the way the definitions I read you from the Iowa Code are going to remain the same, which is that it's about decision-making capacity, and the court kind of looks at different factors of doing that, and those will still remain the same. It's now just when we're establishing the conservative guardianship, all the things that they have to show and pass, which is background checks and all those different things.
Physician record saying,
Exactly.
qualifies that this person has diminished capacity.
Yes, exactly right.
Can you speak to the advantages of a revocable trust compared to a power of attorney?
Well, so you're saying a power of attorney as opposed to a.
Well, the trust can continue on after life.
Oh, it
You
can,
appoint
yeah.
you don't have to go through the
Okay.
conservatorship and then guardian set up, because you can appoint who you want to be your successor.
So
Trustees and.
What Austin is saying is if you have a power of attorney, the power of attorney ends when the person dies. With a revocable trust, you can continue for a period of time, depending on what the trust says, you can continue. Or a will can do this too, you can continue. You can have a trust in your will or a separate trust. You can continue something for a period of time, for example, a farming operation or a business or something like that. Sometimes we've had circumstances where somebody said, I want my children to be able to get the farm, but I also want for a period of time my son or my nephew or our tenant that we really are fond of, even if he's not related, to be able to farm this farm for a period of time after I die. Those are the kinds of things that you can put in a trust or put into a will and say, look, for a period of time, I want you to allow the farmer who's been farming my ground to continue to farm this ground. And sometimes, as I say, is a relative. And by the way, the other thing I want you to do, I want you to give him or her the first chance to buy the farm. And at a price to be established by an appraiser or somebody like that. In other words, a roadmap as to where you want this to go, okay? And I think that's very important too when it comes to businesses or farming operations or whatever. If you have a situation with a farming operation where you want the next generation, maybe your son or maybe your grandson or whatever, to be able to continue to do that, you've got to give some directions about that. If you don't want the farm to be sold to just simply the highest bidder, and many times people don't, they want to keep it in the family, and sometimes we're at the end of that rope and then you just go ahead and you sell the farm, that's okay too. But if you want to give somebody a chance, recently we had somebody that said, look, my tenant's a younger farmer. I don't have anybody in the family who is farming, but I want him to get a chance to buy this, and I want him to get it. I want him to have the first chance, and I want it to be at a price. You don't necessarily set the price, but I want it to be a fair price for a younger farmer, if you will. so that it just doesn't go to the highest bidder. And that's no offense to the highest bidder, if you will, but I want this young man to have a chance to continue to farm. Well, those are the kinds of things that you could try to address. And again, the important thing about that, when you're talking about the conservatorship or guardianship, diminished capacity, these are all things that we can talk about at any time in our life until one of two things happen. We either do have diminished capacity, where we're not able to do that anymore, or we die. I gave a seminar quite a few years ago to some young farmers. And I said, how many of you farm with somebody else in your family? Almost all the hands went up. And I said, how many of you have talked about succession planning with those that you're farming with, that own the equipment, that own the farm ground? Not nearly as many. I said, why is that? And one young farmer said, because my dad doesn't want to talk about dying. And he didn't mean it unkindly. He said, I love my dad, but I can't get my dad to sit down and talk about this. He doesn't want to talk about it, okay? But I always say to my clients, we can talk about this at any time until you die. After that, I can't lean down to the urn of the casket and say, what was that again that you wanted? I know it sounds funny, but
I know one of the things that we always talk with our clients is that what your wishes have to be done in writing.
yeah.
If you die without a valid will, you die intestate, which means you die without a valid will. When that happens, the state of Iowa does have.
Tells you what's going to
Yeah, the
happen.
state of Iowa is going to tell you what's going to happen, and it's not good. So you certainly do want to have a last will and testament, and everybody should have one. As much as we try to encourage that, we still have people walking in and saying, I don't have a will. Our first response is you need to contact somebody to get a will
And
established.
if you do it yourself, 2 disinterested witnesses and a notary.
Is a valid will in the state of Iowa. Yep.
Cannot be someone who is interested or related, needs to be disinterested, 2 disinterested witnesses and a notary.
You can write on a white piece of paper, be one paragraph. I bequest all my assets to go to my spouse or my children or whatever, and vice versa. As
As a
long as
lawyer,
it's
I
witnessed by
advise you
2
to talk to a
disinterested.
lawyer.
No, what's that?
I said, as a lawyer, I advise you to talk to.
I would,
a lawyer.
yeah. But
But he's right, that's why I say that, because people do that, and maybe you're in situations where you can't, that's fine. Just 2 disinterested witnesses and a notary.
I had a question on, so thinking about bequests and giving to charities, are there any impacts that you see with the law changes with any of that might impact how, kind of my process when I talk to donors who want to do a bequest, we check in every couple of years, any changes or anything? And if donors are comfortable giving a copy of the page of their will, where I bequest to blah, 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 organizations, family, anything additional they need to include, or anything we need, just to make sure that we're informing as much as possible.
It's a tricky situation, right, because you can't, the best way, it's easier for a lawyer to do that if they come into your office, but the best way would be is, have you talked to your,
Yes.
right, but
Oh,
you
definitely.
can't, right, I know.
Is there anyone else that
Yeah.
should be included
But-
in these conversations?
And that's-
Because you don't want to be in that position of,
It's also delicate though, because sometimes people shut down if you ask them whether or not they've talked about those things, because if they haven't, maybe they're embarrassed, or maybe there's a reason they don't want to, whatever it is, so it's always a tough situation in doing that. Anytime you probably ought to do this, have a list of whoever else they would want you to talk to about it, next of kin, close, is there, do they have a child who's nearby and assists with their care if they're older, or, those type of things are helpful just to establish, that's more of just a practical establishing that, not legal. The second would be, I guess, would just be prepared, you probably already do this too, but be prepared to have, and maybe continually provide them with updated documents showing their not just their yearly giving for the tax purposes, but hey, here's what your file last year, here's what the 5 years, here's what the 10 years has been. Keep this for your records in the event something like this happens, or maybe you don't have to say in the event something like this happens, but that way they have it for those who keep those records. Otherwise, if you basically it's if you come across someone and they now have a conservator, would be that history of the war giving, as well as having a conversation with them about, you know, what do you need from us to assist in the court process, or is there someone, who's your lawyer that's helping manage this? Will you give them my information, that type of thing?
In terms of charitable giving, I don't think there's, I mean, charitable bequests, as long as it's a charity is defined by the IRS, that hasn't changed. I mean, you still don't have to pay, you don't have to pay taxes on it.
Correct.
And we have a lot of clients that list charities as beneficiaries,
Yes.
whether that's an IRA accounts, life insurance policies, whatever it is, anything that has a named beneficiary, they get list a charity to that. So going back to the power of attorney thing, the power of attorney thing also, one of the things that we see a lot of times missing from a power of attorney is that the ability to change beneficiaries for that power of attorney. You want that ability to be able to change. We've been in a situation where that power of attorney did not include changing the beneficiaries. Well, a person could not change the beneficiaries that were originally written on that contract.
And Tom's
Make
point,
sure that exists.
yeah, that's a very good point. And the other point is, that's a good way to maybe, you know, so you don't have to worry so much about whether or not you have to change your will, or did you remember a charity in your will or whatever. You can designate an account that goes to the charity, and
Yes.
that's a good way to do it. It really is.
Are the tax benefits of donating from your IRA for amounts above the RMD the same?
The tax advantages?
Yeah, okay, that's a good question. I think, so in other words, you have given your RMD or your QCD, you have given the amount that you're supposed to take out in 2019 already to charity, and now you want to give more to charity?
Yeah, say if your RMD's 2,000 and you write a check for 3,000, my understanding is the tax benefits are you get, none of that 3,000 shows on your income.
I think that's correct.
That's
I think that's correct. Now,
That's good, because I'm not be audited for the last couple
yeah,
of years.
no, I see, I had to think through it. I think you're right, George. Now, there is, but I don't think it would apply to any of us here in the room. There are some limits as to what you could give to charities, but it's way above
the RMDs for
It is.
people in our 70s anyway, Mike.
Yeah, no. But George's point, that's a good point. In other words, if you decide to give, your RMD is 2,000, you give 3,000, you still don't have to pay taxes on that additional 1,000. That's a good point, George.
Up to 100,000, that's the QC.
Yeah.
Yeah.
I think that's, yeah, thank you.
It-
Yeah, I think that's fair.
Based upon income, but yeah, you can, and I'm not an accountant, but I do have a client that gives a considerable amount of money to charities, and she's 95. And so she's always worried about whether she's gonna be here next year or not. And her thing is right now is that, and she gets to carry forward some of that charitable donations. So if she went over the limit last year, she can only write off basically that limit and then carries forward the rest of that. And we're in that process this year saying, you can't give as much this year because you were over last year. So we do see that situation occasionally from that perspective, so.
Yes.
Another thing with charitable contributions from your IRA, if it goes to a qualified foundation, as this one is, then they can also apply for the Iowa State tax credit if it's going into an endowment fund.
Yes,
That's
that's true.
another
True.
type.
That's true.
Right, correct.
Although there's not as much money in the endowment
Yeah,
Takes a while.
the state of Iowa's gonna,
so they can, but,
it's a first come, first served basis, I think, too.
I think nonprofits have lobbied to that effect, and it hasn't gone down, but they haven't raised the amount that's available, because it gets snapped up pretty quickly. But that's a good point.
Is the QCDs just for IRAs, not for qualified plans, 401Ks?
I think that's correct.
I think it is too.
Yes, it cannot be from a 401K. It has to
Yeah,
be
'cause
from
then-
an
Yeah.
Yeah, it has to go to an IRA.
It has to go to an IRA.
So if you have a farmer that has a single source or single
Oh, I see,
401K plan,
Yeah,
you have to roll that into an IRA.
Right,
Correct.
exactly.
Correct.
Yeah, that's right. You do.
Correct.
Yeah.
somebody paying capital gains, and they sell that farm, and they put that money into an annuity so that the donor has a lifetime income from the interest, they still have to, does that still eliminate their capital gains?
I don't know.
I don't know. That's a good
I'm not
question.
sure.
I'm not, I
I'm
don't
thinking-
know. I know what you're talking about doing, and you can certainly do that.
The charitable
Don't-
deed trust,
I don't know whether that eliminates the capital gains or not. It
because
would
you
seem to me
have the arms ministry.
that it would follow logically that it would. But I'm not sure about that. It's a good question.
The tax code's not always logical.
We didn't want to open a trust.
Pardon me?
I said we didn't want to open a trust.
I understand,
just-
but you wanted to, yeah.
Can't you just designate the income?
Yeah, you could do that. You could do a lead, yeah, you could do that with the income. But, and you can do that, Phil. The thing is the question of the capital gains, and that's, I'll think about that. That's a good question.
Because you're outright giving the charity to me, I don't know if you get the deduction.
You give the land to the charity, and then the charity has the control and can do whatever they want with it.
That's right.
Then we wanna take the interest back, or the
So it'd be
income
a
off of
charity.
that, and then the
Right.
charity, at the death of the last one, the charity would get the annuity or whatever,
Right.
put it, the money would go to them. And we
So
would
I
keep
would,
that.
I would think I would think that you wouldn't have to, with the capital gains, well, I better be careful not to say that. It seems to be a good, but, yeah.
The market was clear down.
Yeah, I know what you're saying. Yeah, that's a good point.
We had $150,000-200,000
Worth-
worth of taxes on the
Yeah,
land that we
exactly.
sold.
Worth looking into.
Like,
I'll-
lose control. of
We'll
it.
do that and get back to Nicole on that, because that's a good question.
No, I think,
We're talking
The other
coal
thing-
about this.
Glenn, maybe is a lead trust. It
I
sounds
don't
like
want to
that's.
give any trust. I
Okay.
burn out on a trust. Whenever you
I
get
don't think
that,
you have to pay the
I
capital.
don't understand them, and I don't do any of the trust.
It does get a little complicated, you're right. And you have to do it, yeah.
And you have to do it right.
Yeah.
So if they're not set up properly or correctly, they can be kind of a problem.
And it's, and the annuity is something that pays a fixed.
So what you're talking about doing is giving it to a charity,
Right.
but, and you don't want to set up a trust, but retaining the life, the life. And so that'd be an interesting question, whether you could do that. Because sometimes what people will do is they will give something away, but retain the use, income, rents, and profits for it during their life. So if you do that, and the person, or the grantee is a charitable organization, you still get the income, so you still have to pay income tax on that during your life. Then the question becomes, at the end of your life, if you were giving it to somebody in the family, if you reserve the life estate, you get what's called a step-up in basis, and that's a very important thing we haven't talked about. When people die, at the present time, if you have farm ground that you bought 30 years ago, whatever, and you paid $1,500 an acre for it, and it's now worth $8,000, when you die, if it is still in your name, or if you have reserved a life estate, you get a step-up in basis, which means that for future purposes, for families, I would think it would be true for charities, the new value is what it was worth at the time of your death. So that's as if you had paid $8,000 for it rather than $1,500. That's a big difference in terms of, like death tax, I say most of us don't have to worry about that. But capital gains, that takes away the capital gains that you would have paid between $8,000 minus $1,500, okay? With that step up in basis. So if you were to do that, I'm just thinking out loud, if you were to give that and reserve the life estate, yeah, I'll think about that. That's a good question. I mean, that'd be a simple way to do it, if it could do the same thing as
Right.
the lead charitable trust or whatever, so.
So this land we bought, well, that's
Yeah.
1,500.
And it was like, yeah, I understand.
But I don't want to manage it anymore, so I just want to give it to the charity,
Right,
but I want the income off of that dollars to the last
right.
one.
No, I understand. And then the question becomes, what happens, is there any capital gains? Good question, we'll check into that. It's a good question. Yeah, there's a few good
It's
ones.
intended to stump you, but it's a question that we.
No.
Yeah.
That's fine, it's a good question. We can find out the answer.
Okay. You keep track of that.
I am just very new to this process. I'm one of the people that would come in and say, I don't have a will, so where do I start?
Let me say this.
Do I visit with one of the three of you or something?
Well,
I'm not an attorney, so I can't do a will.
Yeah, and we're not trying to, I mean, we're glad to help you, we're not trying to solicit business. to be
No,
honest.
I know, but I'm
but-
serious. I don't even know where to go.
Yes, well, here's the thing. First of all, right at 50% or a little bit more of Americans do not have.
No,
It's just amazing, the number that don't. And that's partly because we kind of put those things off, okay? So, here's what I would say you should do. Number one, you think about what it is that you want to do, or what you want to have happen to your assets after you die, okay? And you might have some special, you need to be thinking about, whether it's children, nieces, nephews, charities, or whatever. Are there people that have some special things that we need to talk about? Sometimes people have children that have special needs. There's something that's called special needs trust, when we get into that. So you think about what you want to do, okay? And then you call and make an appointment with a lawyer and go in and sit down with that lawyer. And he or she is going to talk to you about that and say, okay, let's talk a little bit. All of this is confidential. Let's talk a little bit about what you want to do, and let's talk a little bit about your assets, okay? Well, this is what I have. Well, we're not going to have to worry about death taxes. So what is it that you would like to do? And then we kind of start the process there, and usually have several meetings with clients for purposes, and any lawyer would, for purposes of seeing what it is you want to do, make sure that it's something you can do, which you can, and then begin the process of establishing that will, so that you have the peace of mind knowing what's going to happen to that when you die. The other thing you could do in that regard, sometimes this is a little thing, but sometimes these are things that can create tensions. Lawyers put in a will regularly. Here, I've got a list of things I want to have go to different people in my family. I'm not putting that in my will. Don't need to. We're not going to put every, piece of jade jewelry or whatever. But I've got a separate list, and I've got that list, and I'm going to mention it in my will just so that people know that. It's interesting sometimes. It's things that have perhaps some monetary value, but have great sentimental value that cause problems sometimes. Because somebody wanted grandmother's quilt, and and those kinds of things, and that can create, and not that people don't get over, but that can create a little tension. But if you know how you want to do that, those are the kinds of things that you can make a separate list. Another thing quickly. What are your plans for immediately after your death? Do you want to be cremated? Do you want a traditional funeral? Do you want a non-traditional funeral? Do you want a memorial service? Do you want a graveside service? If you're a member of a church, you're going to be in the church. But those kinds of things are all good things to also try to put down, because when somebody dies, particularly if they die suddenly, all of a sudden the people that are left have to deal with those kinds of things, okay? And if people don't know, they have to kind of guess. When my mother died, she made it very clear to me that she wanted to be cremated. She had been ill the last couple of years of her life. She said, Michael, I just want to be cremated. You can have a memorial service, but I just want to be cremated. And I honored her wishes. Now, at her memorial service, we had the urn there, and one of my aunts said, Michael, nobody in our family has ever been cremated before. And she didn't say it kindly. She said, we're just not used to it. I said, Aunt Shirley, I said, I know that, but that was my mother's wishes. Well, several years ago, my aunt told me, well, Uncle Glenn and I are going to be cremated now too. And I know that's a little thing, but those are the kinds of things that, and you don't put those in the will, but you should, if you know what you want, then those are the things you can write down. So that people,
Like organ donation and stuff too?
sure, absolutely. That's on, we didn't talk about medical powers of attorney. That's right on the medical power of attorney forms.
Yep.
There's also a form if you wish to dispose of your body. Some people want to give their body to the University of Iowa. I mean, there's also a form for disposition of body, if you will. But the organ donor is now right on the medical power of attorney. So that we always ask people that. If you want yes, we put that right there, so people know that.
There's a
Yes, ma'am.
document from the University of Iowa,
Yeah.
but
That is
is
correct.
there anything
It is.
else necessary?
No, there's not.
We have, when clients ask for us about wills and where to start, we've got a will worksheet that an attorney friend of mine gave me years ago. And we just hand them that and says, see an attorney, but it gives them all the questions and asks them kind of, walks them through basically the things that, if they've never spoke to an attorney before about a will, that's kind of that's where to start.
And
It's
it's
an
not,
idea of what they
yeah. Please don't think it's that difficult. Honestly, I mean, sometimes people think, oh my gosh, I gotta go see a lawyer, whatever. It's not, I'm not trying to say it's simplistic, but it's a straightforward process. And financial advisors and CPAs and lawyers and other, I mean, they will listen to what you want done. It's your wishes, okay? That are important.
I would say the biggest question that we get for younger people that have minor children is that if something happened to my wife and I, who's the guardian for the kids?
Right.
Who becomes the guardian for our children? And that's 90% of the reason why they don't do a will, because they don't know who they would be. Because they can't agree upon what sibling would be in charge of their kids, or who would be in charge of them.
No, it's good.
So they don't wanna ask those people.
And they don't wanna ask them. That's the other one, yeah.
But the problem is if you don't do that and you do have smaller children and children underage.
Court's gonna put somebody.
Exactly. And then you ask them to be like King Solomon, and they're not gonna split the baby in half.
Yeah.
They're
You can have family fights over it.
Yeah, and at that point, I always say to people, it's not that nobody will want your children. It is that everybody's gonna want your
Because
children.
they know there's money that comes with it.
Well, or just they'll say, oh, there's my sister, and I'll take care of the children. And all of a sudden, okay.
When we did ours, we listed a guardian was separate from who was gonna be in charge of the money.
Of the money.
Right. So the guardian was somebody else, was my wife's sister and her husband, but the guardians were, not the guardians, but the trustees of the money were my parents.
Yeah.